Good afternoon, everybody. It's good to see you. A lot of faces that are familiar. Can you hear? Can you hear now? Okay. I just want to say this. This project has been fun, but it's also been Murphy's Law. If it could go wrong, it went wrong. And for you lawyers that that speak at seminars and stuff, please don't sign up for one in the spring when they change the law on you, because everything we passed out is out of date already. Susan, I'm going to bring you in a minute. They just amended the law. It went to the governor, Article 134 of the Civil Code. It went to the governor on the 23rd. It was signed. It's enrolled. It's being published, and it will be in effect on August 1st, 2018. You now have 14 factors with a Section B. The original 12 factors are still there, except they have modified 2, and we'll talk about that a little bit later. But the material is still excellent. Luke did a jam-up job on references for the psychology part and psychological part, and to show you how to effectively use these factors both as a lawyer and a mental health professional. It's also kind of designed to help us be able to cross disciplines so we understand each other. It's one thing for me to talk to another lawyer, but when I talk to a mental health professional, I may be talking about, an appellate procedure or something, and I get these blank stares. And so that's one of the first things, I want to talk about is basically, how does a custody case flow? Well, first it's going to go to the district court level. And Susan was a district court judge, and we have Vanessa Randall here, who is also a hearing officer. Gail Luquette over there was a hearing officer. I don't see any other in the court system. Is anybody else here? But yeah, Jean was here. Judge Blanchette's law clerk. So if you file a custody case, it's going to be assigned to the hearing officer for review first. That's the very first step. The hearing officer is going to make a recommendation, which the parties will have to sign, and then if either party does not agree with that recommendation, it's going to go to a court hearing, to the district court judge. In the 15th JDC, which is here, which is Lafayette Parish, Acadia Parish, and Vermilion Parish, we have a family court with 2 district court judges, Charlie Fitzgerald, who I'm extremely proud of because he's my son. But he's in Division M, and then Judge David Blanchette is in Division H. They are both extremely good judges. They're very erudite, they're very concerned, and they're very proactive judges. Same thing with the hearing officers. We've got a pretty good system in place, but like any system, it always needs to be tuned up. So it goes to the district court judge, and he tries the case. He swears in witnesses, or she swears in witnesses, and then testimony is taken. After all the facts are in, the judge is going to make a considered decree. Now, we're not like Texas. You're just going to have a judge trial. You're not going to have a jury trial for a custody case. I can't imagine that, but that's what they do in Texas. And if you disagree, if you lose or disagree with parts of the judgment, you have the right to appeal. So we have 5 circuit courts in the state of Louisiana, courts of appeal. For us, it would go to the 3rd Circuit Court of Appeal in Lake Charles. Judge Katie is our justice, from this area. So what happens then is they will take a look at the cold record, because everything that was said in court has been transcribed into a record. All of the evidence that the Circuit Court of Appeal will see is what's in that record. There's not going to be any more testimony or anything else. Then you go there and you argue it. If you don't like the result at that point, you have the right to apply for writs to the Louisiana Supreme Court. Unless you have a very unique issue, you're probably not going to get writs granted because they're there looking for where, like I said, there are 5 circuit courts of appeal. Okay, in those 5 circuit courts of appeal, there may be different opinions on how you handle a case. And in one of them, we have a recent case which we're going to talk about today. 3 of the circuits would go one way on a custody matter, and 2 would go another way. Well, the Supreme Court cleared it up for them. So the one that is really important to us would be a Supreme Court case. If there is no Supreme Court case on the issue that we are looking at as lawyers, we will go to the Circuit Court of Appeals cases. If we're in the Third Circuit, if we're in the Third Circuit's jurisdiction, we're really looking for what the Third Circuit says on this issue. The Second Circuit may say something differently. Well, we can certainly cite that if it supports our position, but the lawyer with the Third Circuit case probably will do a little bit better. So I hope that clarifies a little bit about when we're talking about cases, how they get from A to Z. The first case, who's handling? Okay, give me the first frame, please. Yeah, Hodges versus Hodges. It's 181 Southern 3rd, 700. It's a 2015 case. And Judge Weimer wrote the opinion in this case and in the next case that we're going to talk about. But this is the first thing he says, right off the bat, and this is the paramount issue always in custody. The best interest of the child is the sole criterion to be met in making a custody award, as the trial court sits as sort of a fiduciary on behalf of the child and must pursue actively that course of conduct that will be the greatest benefit of the child. That's... He's
going to show you how to turn that on so you can turn around and move.
Okay, excuse me just a second.
Oh, yeah, so you have it right here. And they gave you a new battery, I think.
Good.
And so it's all...
Okay. Yeah, good, great. Thank you. Feels strange. Yeah. So, anyway, the Hodges case was an important case because prior to Hodges, there would be some judges in the district court level that would award co-domiciliary status in a joint custody case. Well, there's no statutory authority or civil code authority for the judge to do that. The Hodges case cleared that up and said, no, you can't do that. If you're going to have co-domiciliary, it's going to be by consent judgment only now. But anyway, in your materials that we gave you, just a copy of it right here. If you'll there's an introduction that goes through what Judge Weimer said, and I'm not going to read it to you, but I would ask that you'd read it when you have time. He's explaining the law and analysis of a custody case. It's one of the best pages and a half that I've ever read on what you're going to go through. The Civil Code Authority, when we look at custody, there are basically 4 major articles that we work with. Article 131, which is it's going to be in the best interest of the child. That's always paramount. That's what we're looking for. So then 132 goes into how you're going to award custody. And in most cases in Louisiana, it's going to be joint custody now, it's presumed. 133 gives third parties the right to ask for custody. In a lot of cases now, especially in South Louisiana and in our judicial district, we're seeing where grandparents are having to step up because of what? Drugs. Yeah. I mean, everywhere. Everybody was saying it. So the grandparents can come in under Article 133 and ask for custody. Then we have 134. once there is a determination of custody, you're going to have to look at what's, I mean, while you're making this determination, you're going to have to look at Article 134. And that's the factors, the 12 factors right now today that are the old law. These factors have never been exclusive. They were illustrative. They certainly cover most of the ground that we're looking at in a custody matter, but they don't, you're not excluded from going to other places where there are other issues. If there's sexual abuse or physical abuse, you could certainly look at that. If there are, any factors that would come in for that child, because each case stands on its own merit. Give me the next one, please. And it's one of the things that I learned practicing custody law for a number of years. When they came out with these factors in 1992, that here we had a guide now. Let's see which one of these are applicable to our case. And we would take the factor and we would start going through each one with the client. Well, initially, the mistake I made, and a lot of other attorneys made, was in factor one, the love, affection, and other emotional ties between the parties and the child or children. We kind of would gloss over it, like, okay, well, they love their children, children love them, and they've got good affection for their children. They're bonded and attached, and whatever. And we would just kind of gloss over it. But as time went by, and as we were trying more and more of these cases, it was like, hey, let's start with one, because if you really do a thorough analysis of one, the love, affection, and other emotional ties, you're going to answer about 5 more of these issues from that. And that's what Luke has done in here, and what a lot of his talk is going to be about, is to show you how to do a very thorough analysis of best interest of the child, factor number 1, which is now factor number 2. But anyway, it's amazing how this stuff works. And as we were going along in the practice, back in the 80s, we started seeing a lot of sexual abuse cases come up. And we also started seeing a lot of domestic violence, or started seeing it, being brought more to the forefront. And, we started questioning, like, okay, we're in love and affection. This guy's sitting here being a perpetrator of children. What kind of love and affection applies here? So, you start seeing how it works. And the case that we've chosen to, let's see, go to the, yeah, I want to go to big factor 1. It is Tracy versus Francisco. It's another Supreme Court case. It's a 2016 case. And again, Judge Weimer wrote the case. And he is, again, they're making a decision from that cold record. They read the record. If the facts are there to support your position, you're in good shape. If they're not, you're not going to win. But this case, it's Tracy versus Francisco.
It's on her screen, but not on ours.
Yeah, go to the next one. You're still on Hodges. Okay. Well, I'll forget it. It's in your little book if you can follow with me there. But in Tracy versus Francisco, you have a case where the mother has an affair with, her name was Tracy. She has an affair with Francisco, and they have a son, D. Within 6 months of D being born, Tracy moves back in with mom and dad. Tracy is going out and getting involved in the local scene, and she gets hooked up with this boyfriend who gets her on drugs. So Tracy starts getting more and more out of the picture. At about 4 years old, when Dee was about 4 years old, her mother, Kathy, the grandmother, decides she needs a custody order because she's been taking care of this child now from 6 months to present, and her husband, the granddaddy, he's the father figure, she's the mother figure. So she gets with Francisco, and they file a joint petition to name her as the domiciliary parent, in this matter. They didn't know where Tracy was. They finally found her and roped her in, and she signed a consent judgment to allow that. So Kathy has a consent judgment. Francisco is not involved in Dee's life for the first 7 years, of Dee's life. He has nothing to do with the child, doesn't provide child support that we know of. It's not in the record, okay? But there's a comment. We don't know because it's not in the record. So this gets... So anyway, Francisco decides that for whatever reason that he wants to be involved in Dee's life. At 7 years old, he gets involved with Dee. After being involved with Dee, he files a suit to change custody. Now, we know that parents have a paramount right to custody, biological parents. Well, when you have a consent judgment, it changes the game. He's got to, when he files his suit, he's got to prove a material change in circumstances, which he does. He proves that he's now involved in Dee's life, which I guess is a good thing. And then you've got to prove, after the court finds a material change in circumstances, you've got to prove it's going to be in the child's best interest. So they go to Article 134. And what Judge Weimer does is he takes each element, each factor, and starts looking at the record and applying it. So he says, we find the record evidence on some of these factors is equipoise. That means, equally balanced for factors 1 and 2. Now, this is the first question I have. How in the hell can that be equal? This guy abandoned and rejected his child for 7 years. Now he's getting back with the child, which is okay, that's good. Hopefully this is a good guy. It sounds like it might work. But how is that equal? So when you do a thorough analysis like Luke can show you, when you can read in the handout, she should have won. Kathy should have had that right there, and then that would have taken you through 5 more, would have saved everybody almost a lot of time, because she would have won 6 right off the bat, and should have had 9. But they find it equally balanced. That's because we overlook the basics. And that's what, hopefully what we can do. Go up one more, please. We can unpack this thing. Talking about thinking out of the box. You got to know what's in the box before you can think out of the box. And so, unfortunately, we didn't know what was in the box until this week. But at least the love, affection, and other emotional ties between each party and the child are there. So let's go with the definitions. I love the way Dr. Bernay took that definition of PA and carried that thread from Jump Street all the way to present. I think that's wonderful. It's the same thing you need to do when you're looking at the law. Okay, what is love? And this is a good question to ask your clients too. What's your working definition of love? Anybody got a working definition of love? Well, this is what we came up with. In this context, between a parent and a child, it necessitates certain family loyalties, responsibilities, duties, and entitlements. That's familial love. In Greek it's, stores or storge, however you want to pronounce it. But it's to be a sanctuary for its members to pull through together in life's difficult times. And then the second part of that is agape love, unconditional love, sacrificial love. If you're a parent, you know what I'm talking about. Then the next part is affection. It's referring to positive feeling that we express both physically and verbally for another person. With a parent and a child, it's back and forth. This is going to impact a child throughout his life, the affection that the child is given. And then the last thing would be other emotional ties. Especially in this area where, we're a very large Catholic population, but there are a lot of other different denominations and churches. That is a big activity, a big family activity that takes place. That could be one. Another example would be a parent coaching a child in sport like soccer or whatever. And then, other shared hobbies and interests, fishing, golf, whatever they do. So we look at that. Now, when you take Francisco and you look at those definitions that we were looking at earlier, you can start seeing that there's a lot of unhealthy behavior that Francisco exhibited for the first 7 years of the child's life for sure. Now, rejection and abandonment is a huge, huge issue. There's a lot of literature, and we're not really here for that. But this child is going to have some issues with rejection and abandonment. I don't care what anybody tells me. The next part of it, what we found through time, and that's why I see a lot of old lawyers here. I say old lawyers, young lawyers, but older lawyers in the practice. But I see a lot of them here. Everything Dr. Bernays said this morning, we've experienced with our clients. We see it all the time. Now we got a pigeonhole to put it in. I'm not here to advocate for litigation, though. I'm here to try to advocate for finding out what's really going on. If your client's suffering from, this dilemma, get them help. Because we want healthy parents. We really do. I know lawyers take a lot of bad rap about all we want to do is go to court. That's not true. You can ask anybody in here that has been practicing law for over 5 years in the domestic arena, and they will work hard to try to find a good solution. And a lot of times we're relying on you guys, and I'm talking to the mental health professionals. Help us. Tell us what we need to do. What kind of boundaries do we need to put in here? What kind of help's available for these clients? So this is where we can cross with each other and do each other a whole lot of good. Now, I'm not going to go through every factor, because I don't have time, number one. I'm just going to tell you that Kathy won, but the little handout will show you how Weimer and the other justices applied that to the facts of the case. You want me to say anything about 10 right now, or you want to wait on that? Okay. So I'm out of time, guys. Dr. Luke Elliott, who I have immense respect for and loved working with on this and through the years.
Well, as you've heard today already, there are many different definitions of parental alienation, and I have picked one to focus on today that didn't get covered directly, but still important. If you remember, he said it's the alienating behaviors of the parents that is what causes the abuse. And Darnell's definition, which again I'm happy about because it's old and it lets you know that this is not all new, describes actions that a parent intentionally or unintentionally takes. Well, the unintentionally part would cover the mild type of alienation. The parent who isn't really quite aware that their anger and hurt is pushing them to be so ugly and loud and denigrating about the other partner in front of the child. And as we heard, that can often be addressed. But there are people who intentionally do it. And some of them are so hurt and angry, and they know it, and they want revenge. And so they don't worry that they're hurting the child, as it says, regardless of the impact. And this is where good parenting and love and affection go out the window. If you're not looking for the best interest of the child, then clearly something is wrong. And as we've seen, many people, and you saw Greg Childress is one of them, really thinks most of those people have some sort of a personality disorder, borderline, narcissistic. The splitting is taking place, and they just can't see what they're doing. But the reason I'm up here today is that without this awareness that you're gaining today, the alienating parent often wins. And you can find case records where the alienating parent won 6 or 8 or 10 of the factors. Why? Because they had time with the child. They claimed they loved the child. They took the child to school. They provided. They did. You know why? Because they excluded the other parent completely. The targeted parent had no chance at doing those things or proving that they love the child and want to do them because they couldn't get custody. They couldn't get time. The time, contempt of court orders probably should have been issued, etc. So what we have today is a rainstorm, which we all need. I know you're all wondering, what does that sound? I think it's thunder, although it's still bright. So a little bit of a review today. You heard probably in your freshman year, if you want to teach something, you tell people what you're going to tell them, you tell them, and you tell them that you told them. So as far as I'm concerned, this is only the second repetition. And then if you read it when you get home, that'll be the third. One of the big things that puts children in the middle and causes a lot of psychological harm is the parental loyalty conflicts. Parents trying to get the child to take a side. It puts the kid in the middle. There are books and articles written called Caught in the Middle, describing what they go through, and particularly interviewing teenagers who can verbalize. And they can't, you would think that, teenagers are so strong and, they're going to blow off anything. Oh, the latest. I don't have good jokes like Dr. Bill, but you know what a teenager tells you when a sales clerk says, "Have a good day"? Don't tell me what to do. Right? And so a lot of people assume that adolescents are going to say, "You're both nuts. I'm not worried about this. I'm going to do what I want." But they can't. Developmentally, they still need love and affection. They need someone to give them guidance. And so they're horribly caught in this conflict because they can't honestly express their feelings. If mom is domiciliary and she's down on dad and you love dad, you're going to be with mom for the next 5 days. You're going to come home bragging about what a wonderful man dad is and how much fun you had with him and risk her wrath for 5 days. You might. Then you're miserable for 5 days. Or you can keep your mouth shut and then you feel like you betrayed your father because you didn't defend him. You didn't say a word. You effectively agreed with her. That's what it looks like. And then she'll say, "Oh, look how close we are." So putting the child in the middle is harmful, almost all the time. And if the alienating parent succeeds, the child loses contact with a parent. And that's where, until recently, the research and the concerns have stopped. That you don't want a child to lose half of themselves. They're genetically half that other parent. And I do parent A and parent B, A being the alienating parent, to avoid getting caught in saying he, she, mother, father, all right? But you can't, parent B is half of you. Genetically, that's exactly half of all the messages that you carry and the tendencies and the way you make the letter number 5 differently from your brother. So you're telling the child that person and everything in him is horrible. It's evil even. What are you supposed to do with the fact that that's half you? And worse if the parent says, you do it just like parent B. You write just like parent B. Or you're sloppy just like parent B. Well, there's the condemnation. Now it's on the child. Now, how do they struggle to accept that? Well, the later research is showing that over time it backfires. Particularly when the kids get out of the home and they get more in touch with healthy psychology, they realize what a horrible selfish manipulation was happening with parent A's alienating behaviors. And they realize, not always, of course, but they do, the stories weren't true or they were exaggerated. Or daddy had a perfectly logical explanation for why they left him at camp or whatever. So that takes a lot of time. And the child may or may not regain closeness with the targeted parent. If the alienation was severe enough, sometimes they just can't overcome it, which is, of course, tragic. Conditional love. We just saw love and affection. But imagine how diabolical it is to figure out when you're 5 and 6 years old that your mom or parent A loves and is affectionate with you until and unless you talk about parent B. And then suddenly that love is gone. And so the child soon learns, oh, I'm going to talk about you only and all the things you do and how happy I am with you. Because when I talk about parent B, I'm losing love or I'm being threatened with it. But if you really believe the threat, it's as bad as if it happened. You are already harmed. You're anxious. And as you saw the studies, anxiety and depression almost inevitably follow from these kinds of situations. So implied is bad enough. The active loss of love is extremely threatening to a child, and they will do anything to try to get it back, whether that behavior is good, bad, or indifferent. And if it's expressed over time, it really gets into the child's consciousness. One of the things I'm going to mention now and again later, psychologically speaking, you're understanding now what happens is we're preventing the child from developing a self, not you and me, this kind of parenting. They don't have time to think about who they are and what they like. They don't have time to be an individual with their own beliefs and tastes. They're constantly being shaped and punished effectively unless they believe and say what parent A says. And so when you have the personality disorders and the concept of splitting, again, for repetition's sake, I want to mention, the easy way to understand that is parent A marries parent B. Okay, we'll do mom and dad. Mom marries this man is now her husband. And then they have a child, and that is the father. But if you're no longer married to me, if you divorce me and you're not my husband, then by definition you can't be the father of my child. That's how severe splitting is. You're either one or the other, black or white. If you're not here for me, you're not here. And so therefore they feel justified in attacking this person and turning the child against this person. I mean, look what they did to me. Right? Okay, enmeshment. This comes from attachment theory. Attachment theory, if you haven't read over it lately, is a fascinating read. To go back and see how early it develops, to realize that fathers got the rights to have children in early years because attachment theory proved you could be attached to more than one person. You could have a secure attachment to 2 or 3 or 4 people. And they used to use, the mother and the primary custodian and the psychological parent to keep dads from having much custody under age 2. Falsely. And attachment theory proves that's wrong. And so the American Psychological Association said in the 70s it's baseless to discriminate custody on the basis of sex. Dads can do good mothering if they have the child, if they have the time, right? Are there screw-up dads? Yeah, we all know that. I'm just saying, given adequate people with the good intentions, attachment is very powerful. It goes wrong when one parent, if you remember your biology, where this little cell is there and it bumps into this other cell and then suddenly it's one cell, it's bigger. Enmeshment, one parent violates the boundaries of the child so badly that they're telling them what to think. They're telling them what to believe. They're providing an identity self already done, complete. And the child is too young and inexperienced, has no cognitive capacity to go, wait, Mom, that's wrong. So they believe it. So that's bad enough. But if part of the mother's belief system is a systematic exclusion of the other parent, and the child is enmeshed with the mother in this case, then they believe that too. And so what we at BOI like about this definition of Darnell's is that we're not scapegoating the child and saying, let's identify everything wrong in the child. Let's understand where it came from. And it came from the alienating parental behaviors. And these are the things you got to watch for. When you see a parent and a child that are very close, you got to watch if they're too close. And again, unintentional. I learned so much from my secretary and the waiting room when I was doing therapy, because they're off guard. I learned that in my internship in Memphis. Our offices were on the second floor, and there was a grand opening, and the waiting room was down there. And we soon learned the best thing to do is hang out there for about 10 minutes, just where you can see them, they couldn't see you. So a few years ago, before I closed my clinical practice to do this, there's a mother with a perfectly healthy football-playing 9-year-old boy on her lap in the waiting room, hugging and snuggling like they hadn't seen each other in years. And when I mentioned to her that might be a little inappropriate, she's like, no, all right, and there was no alienation going on here. This was just a case of poor boundaries. So I don't want you to think only alienators do this stuff. Enmeshment can happen in any number of families for any number of reasons. Usually it's private. Tucking the kid in, reading stories, telling them what to think. Why do you see it? Nobody sees it until an action is filed, a divorce, a separation. It comes into public view. And then it all gets looked at. One other clarification that covers the entire day. The word divorce is a convenience. 50% of marriages right now in our country end in divorce. Who knows how many people never got married in the first place? But if we had to stop every time and specify, the 4 different ways of one-night stands, shacking up, living together for 4 years, we'd all lose the point. The point is the separation of a mother and father from each other, and when or if they abuse the child and misuse the child. So I say divorce for convenience, but it means anytime the parents break up, however much they were together. Or if the grandmother raised them and the grandmother does these things. So divorce is a convenience. So here again, I'm making sure you understand the child needs to develop a self. They want to say, I want to be a fireman, or I want to be a cowboy, or a little girl's going to be a fireman or a dancer. And they need the parents to say, great. I hope not, but yeah, great, that's wonderful. Right? And so that's how they begin to test out their ideas and find out, guess what, I'm too spastic. I can't be a pro basketball player. I can't hardly tie my shoes. I'll walk into walls. I'll drop books, so I'll be a professor. Whatever. They have to find their way through. And when the parent is constantly telling them what to think and how to feel and what to believe, they don't have time for that. That's the long-term harm to the child. They don't even know who they are. And if they begin to find it and begin to express it in terms of love for parent B and they get slammed repeatedly, one logical question is, well, maybe parent A is right. Maybe I don't love parent B. Maybe I shouldn't love parent B. And now they're losing their self, which is another factor in parental alienation. Parental psychological control. I realize that this is like a review course for most of you, but this is a concept that has slipped out of vogue, so to speak. It's very insidious. It's seen in every situation across the board, when you find it. But it's particularly a problem in parental alienation. And what's going on here is not healthy discipline, limit setting, raising the child, socializing them. No, what's going on is the parent wants to control the child. They want a little robot. They want a child that does what they say, when they say it, without question. Now, you say, well, isn't that a well-behaved child? Well, possibly. If you use love and praise, and the child is happy to do it, and the child brags to other people how good they are. But if you're using domination and criticism and even cussing at the child to make them do what you want them to do, then you're controlling them. It's coercive and it's unhealthy. and it can become abuse in the extreme, particularly if you're coercing them to do the wrong things. So parental psychological control is a big deal, is probably borderline abusive all the time, but we have to, again, be very alert for that. If the adult's behavior doesn't reflect the best interest of the child, a red flag should go up. It may not be alienation, but you should be alert for it. And if the child lives to please the parent and is fearful of not pleasing the parent as opposed to happy when they do, we probably have a problem. And when parent A is actively trying to alienate parent B, the child's healthy development is in jeopardy. I'm afraid there's no way around that. And the criticism and anger gets dumped on the child if they like or express their like for parent B. So far, so good? Questions? I know we drew the short straw. Not only did you have potatoes and fried food and dessert in one small cup of coffee, you know, the carbo load is like, y'all awake? No, seriously, any questions? Okay. So, thank you. This needs to be talked about again. It needs to be talked about in terms of having a jaundiced eye. When people say something, question it immediately. Wonder. Always talk to both parents. You know, that thing that Dr. Bill spoke about is totally true. A parent comes in and reports all this bad stuff about the other parent. You go, even a seasoned therapist, you go, oh yeah, well, maybe, maybe not. I'll see what the child has to say. Well, if the alienation's going on, what's the child going to say? All that in a bag of chips, right? And then you go, yeah, this must be something real here, if you don't interview the other parent, right? And I almost made that mistake, I'll happily admit, when the daddy who was accused of sexual abuse in a divorce situation, funny how those things come up, isn't it? Called me and said, I didn't do it and I want to talk to you. I said, you're the father, you're welcome. I believe your child, but please come on in. And it turned out he didn't, ever. I mean, we went to the point of the sheriff, the court reporter, the deposition, everybody in my office, and the child wouldn't say a word. And after it was over, I know y'all typed, you know what WTF stands for, right? That's what I asked the child very mildly. And he said, well, Mama said I had to say that because Daddy wasn't going to give us enough money, and if we didn't get Daddy, then blah, blah, you know, all this. I was like, are you kidding me? I called the father back. But that was also the poo-poo pusher episode. I'm going to keep you awake. The poo-poo pusher episode. Little kid comes in and said, I was at his daddy's house and he showed us this great book about the poo-poo pusher. I know where your mind's going. Uh-huh. Richard Scarry's best storybook ever. Richard Scarry's best airplane flight ever. Richard Scarry's medieval castles. The royal throne had a royal pot that had a channel that fell down to where the servants lived. And in the picture book, one of the guys opened the door and pushed the poo-poo into the moat. It was a story about a poo-poo pusher. Now, this is in the context of I'm evaluating, is this child being sexually abused by his father? Right? Do you see how easy it is to get misled? And you see how these otherwise bright little boys were so intimidated by the alienating mother that they were lying to the point that the policeman and the court reporter were there before they wouldn't say it. You going to remember that? Okay. You got to have a jaundiced eye. You got to question. So I just want to make a comment about a couple of these things. The spurning comes down to the belittling, which we've heard, and ridiculing and criticizing the child. Hopefully not so that they think their name is idiot, right? But that they can do nothing right, that they're the problem. The terrorizing was well covered. Remember, physically threatening is assault. If you touch them, it's assault and battery. So when parents are getting after the kids and threatening to do harm to that child or someone they love, in this case, alienation, parent B, that is terrorizing. Isolating, again, is very clear. Dr. Bill did a beautiful job on that. I just want to add, they isolate from the extended family, right? You don't get to see Tina Nu and Nonk Edward and your cousins and your nieces and your nephews. They're all gone. Remember, half of your DNA? Well, half of your entire life. Extended families. By the way, if anybody knows this is true, tell me afterwards. I've heard from several sources the town of Broussard is so named because 100 years ago, Mr. Broussard had 6 kids. And as each one of them gotten old enough and got married, he gave them a piece of land right around his house. And over time, when people were trying to give directions, they'd say, well, you go east over there to where the Broussards live. And ultimately, it became incorporated as the town of Broussard. I don't know if it's true, but it gives you a feeling for Cajun culture and family and the importance of extended family. And how many of you spent time in the summer away from home, weeks at a time, because you were with cousins, aunts, uncles, right? And every major holiday, was it just your immediate family? No, the loss of the extended family is very crippling to these children. It almost disfigures them from understanding normal family relationships. The exploiting can be the antisocial behavior that was mentioned, but also the developmentally inappropriate behaviors. And we go back to attachment theory. The infantilizing, where the parent cannot let the child grow up. The parent that is happy and loves an infant, and they're the best parent for an infant. And the minute the kid can say no, their parenting goes way south. They're threatened by that. And so they keep the child needy and dependent. That infantilizing, that's part of an attachment disorder. And what happens is these children don't grow up. And again, if this parent is isolating and corrupting and terrorizing, this child is not going to turn out normal. And the other one is parentification. And this is when you can misunderstand, you can do any lie you want with statistics. That it is a fact that children divorced in general are a bit more mature and independent than children from intact families. For a lot of reasons. I mean, they get to see mom and dad's warts. They are given a little more responsibility. Most competent children handle it and like it because they're succeeding. But when a parent has the need for a spouse and they've lost one and they make the child the surrogate spouse, they make the child help with decisions and pick dinners and clean up the kitchen and do all this work and treat them as a parent and confide in them. Sexual details, let alone money or court hearings or what the judge said or, they just overload them and treat them like a parent. Why? Because the parent needs it or because the child needs it? The child doesn't need that. And the child, if they're really strong, will say, would you please quit talking about that? Which is one of the most fun bits of feedback I ever got in the middle of divorce. I told this very nice young man, I said, look, when that happens, stand up and say, Dr. Elliott said, I don't have to listen to this. Please quit arguing. Now, sometimes they told him to go to his room. Sometimes they quit arguing. But his chest grew about 4 inches in one session. He was no longer powerless. People that are on this board, they don't have that. The rejection comes from the idea that you avoid the child or you push them away. But again, I want to remind you, if the parent doesn't reject unless it's concerning parent B, and then they reject, it's very harmful and very confusing. And this, happily, is codified in the DCFS Guidelines, Department of Child and Family Services. This is a quick overstatement. The formal wording is being developed. You have the C where they're saying, now wait a minute, isn't this just a partial summary of everything we said? Yes, it is, but here's my point. This is what the average, naive, brand new caseworker knows about parental alienation. This is when they get introduced to it. This is the information they have. So you say, well, it occurs when a caretaker's often in high conflict and turning in to caretaker, turning in blah, blah, blah for invalid reasons. You go, well, wait a minute, we've been talking about that all day. Yes, we have. And how much of a benefit do you have? And what an edge do you have over the next parent that walks into your office? But this is codified statewide, or will be, the formal language that will be adapted soon. So the child knows all this. Specifically, the child allies himself strongly with one caretaker. Did you hear that this morning? And rejects the other one without legitimate is that familiar at all? Yes. To you. That's the fourth time you've heard it. But it will be the first time the workers hear it. And that's the importance of it. It's no longer debatable, discussable, disprovable. It's there and it's real. And these workers are going to get it. And Dr. Eric Green has had a lot to do with getting this done and continues to work and continues to offer grants that we're using to further train the workers. But I wanted to conclude with something that we are very happy with. So it was mentioned that we have given some grants to ULL faculty psychology department. And one of them was attempting to replicate a study out in Arizona using jury pool participants, not the white rat of psychological research, the College Southmore. All right, these were 18 to 65-year-old cross-section of Acadiana sitting, waiting to be called for jury duty. And guess what? You ever been there? Were you in and out in 10 minutes? No. Your behind went to sleep because you were sitting for so long, right? So we approached them and said, hey, we're from the university, we're doing some research, would you like to participate in a little survey? And the response rate was like 90%. They were, I think, truly happy to have something to do. And so we asked them a bunch of questions about if the parents divorced for this reason or that reason, how much time do you think mom would get and how much time would dad get? And the short answer is your neighbors said 50-50. I mean, there's little wiggles, but basically they said 50-50. And so we asked them, well, whether the parents are married or not, remember so many of them are not, do you think ongoing parental conflict causes emotional harm to children? Now, out in Arizona, the huge majority thought so. The reason you do replications is we want to see what Cajuns thought, right? Are we normal? Do Cajuns think the way the rest of the world thinks? 84% of the jury pool people said, is it wrong, does ongoing parental conflict cause emotional harm to children? 84% said always or almost always. Do you believe it's morally wrong for one parent? Morally, you heard that? We snuck that in. That's not a psychological term. Do you believe it's morally wrong for one child to say bad things about the child's other parent in front of the child? 88% said yes, always or almost always. And the one that really is the clincher for PA, we have heard the name of Amy Baker, and Amy Baker has done a lot of good research. She had 20 questions, 17 important ones. The top 10 you saw already this morning, there was one that predicted everything. Did you ever feel your parent was trying to turn you against the other parent? The ones that said yes to that, you could almost predict the rest of the answers. So we asked our good citizens, is it morally wrong for one parent to try to get their child to actively dislike the other parent? Okay, the highest number we have so far is 88%. We're going to go up or down from there? Up. Thank you. 96% said it's morally wrong. Yes to always or often. And they predicted. Now, there were no judges involved in this, all right? No judges were harmed in the making of this survey. But we asked them, what do you think a judge would say? And they predicted that 90% of them said the judges would also agree it's morally wrong to try to turn one parent against another. So even if you didn't know the word triangulation or parental alienation, but you always knew it was out there, you didn't know what to call it, now you know what to call it. And now you know that all your colleagues and friends think it's awful. 96%. So I very wisely have left 90 seconds for questions. So I can get out of here. No. Yes, ma'am.
For the lawyers in the room, a lot of the people that are guilty of parental alienation are extremely litigious. So that means if probably already been to court, maybe more than once. They're not the kind of people that settle. And here in Louisiana, we have a standard that says if you've tried your case and you need to come back, it has to be so deleterious to the child.
Bergeron? The Bergeron?
To make any changes, to even get back in court. So we have this high burden to get back. And when we're talking about the effects of this parental alienation, are there any studies that we can look to so that we can flesh out for our judges what those damages are, to really get the point across that this is more than just depression and anxiety? Because I think people don't really take that as seriously as.
Okay. Now I'm supposed to summarize that. If you didn't guess, she's an attorney. Okay. She said, does the audience know that most people that are involved in parental alienation are very litigious? They love to court. They go to court. They fight over little things. And yet there is a standard, the Bergeron standard, for those who are familiar with it, that says there has to be a substantial change in circumstances once you have a considered decree, right? And so how do you get back into court? Suppose you come across this, all the things we've been talking about, and you know the child is being harmed, but you need to cross that bar to get into court to get the case reopened, as it were. Did I summarize your question?
Yes.
Okay. Did anybody have an answer? No, teasing. At the back of that book, there's 2 pages of references. As you read through each factor, every time I make a statement in there that they found depression, there's a study named. All right? There's, how many references did we end up with? 40 or 50 references
You're talking about Bergeron?
as a way to get to proving that there's actual harm to the child.
For substantial change.
Change in circumstance. This is so they couldn't go back to court every time, they wanted to change schools or put them on a soccer team.
That's what I'm saying, is the question showing substantial harm or is the question showing substantial change?
The answer is yes. In other words, you have to get into court to prove a substantial change. And she's saying, can that change be that we're documenting harm to the child from the current arrangement? Is that what you're saying?
When you're a sitting judge and you're a hearing officer, don't I need to show damages to the child?
But I think there's the other question.
Well, I was just looking for studies that would flesh those out.
Yeah, and I gave you an answer. I think it'll help. But I would also say, in the interest of other people who are not interested in court, that Dr. Brene, Terry, and all of us will be here right after this is over. We can take 10 minutes and really flesh that out for you.
Just one quick question.
Yes, sir.
You talked about the New Beginnings program that is in the works to identify parents.
Do you have that schedule
maybe
change
on the
put up here?
verge of parental alienation, because the problem
You have the
is trying
schedule
to stop
change?
it from the get-go. Y'all see it as mental health professionals. We see it as lawyers, but we don't know how to deal with it other than to say, go see a mental health professional. And sometimes that doesn't work. So can you address that yet? I think
Well,
y'all are hopeful.
yeah, this is an idea only. Dr. Donna Oakwow, I'll give credit, has allowed us to house the New Beginning program from the very first day we offered the group. And she's also been constantly watching and seeing, is the New Beginnings program really 100% effective? And it was mentioned this morning, about 80% of the time, it seems to really, really help people. And the judges like it and tell us directly, we love it because they're not coming back to see us. So it's settling people down. They're not fighting so much. But there is a percentage, for sake of discussion, we'll say 20%, that still need work. They're still hating the ex-spouse to the point that they can't be in the same room, they can't be civil, they can't do this, they can't do that. And they're not all personality disorder. So we have, with Dr. Oakwand's input, or we're getting ready to pilot a new program that'll also be 10 sessions, but will also involve the children and will also involve direct parent-to-parent communication. That's all. What I just told you is as much as we know. We haven't done it yet. We haven't set up our first group yet. Okay? But stay tuned. Come back to our next presentation and we'll update you.